Professor Michael Krause from the George Mason University School of Law in Arlington, Virginia. And Professor, thanks so much for your time this evening.
It's my pleasure.
I wondered if we could discuss the Maryland gun case a little bit here. I was reading an article in the Baltimore Sun talking about the likely arguments for an appeal. But if we can, let's talk a little bit about what the decision actually was in this case in federal court.
Absolutely, it's my pleasure, and it was a fantastic decision from the point of view of those who defend the Constitution. What your listeners have to understand is that Maryland is one of a very small number of states that does not allow a right to carry a firearm that one owns legally outside the home. One must request permission, and it's discretionary on the part of the superintendent of police of the state of Maryland. And the criterion that the superintendent is supposed to use is whether the applicant has, quote, a good and substantial, unquote, reason to carry a firearm outside the house. And, of course, as your listeners probably can imagine, the great majority of Marylanders who claim that they wish to carry a firearm for purposes of self-defense are told that that's not a good and substantial reason.
Mm-hmm.
So one such person had standing to sue because, and most people wouldn't have standing to sue, but one such person had standing to sue because he had a permit. These permits last 3 years in Maryland, and the permit was not renewed because his reason was apparently no longer good and substantial, the same reason that 3 years earlier had been held to be good and substantial. So he brought this to court, and the U.S. District Court, I think, rendered exactly the right decision, deciding that you don't need a good and substantial reason to exercise a constitutional right. The fact that it's a constitutional right is in and of itself a substantial reason to exercise it, much as the state of Maryland or any other state could not limit my First Amendment rights, my right to free speech, for example, unless I had a, quote, good and substantial reason to speak. Similarly, it can't restrict my Second Amendment rights for such reasons. And so the suit was allowed on summary judgment. There was no full trial. This is a pure question of law. All the facts in the case were conceded by both parties. There was no dispute, no jury or anything like this. And it was a very clean victory for defenders of the Constitution.
So what do you think, Professor, is the likely argument that the state will use in their appeal of this decision?
I think it's fairly clear that the state is going to claim that it believes that the Second Amendment, as interpreted by the Supreme Court in Heller and McDonald, Heller, which confirmed that there is a Second Amendment right to own a firearm, and McDonald, which applied that Second Amendment right to the 50 states as opposed to merely the federal government. The state of Maryland is going to claim that that Second Amendment right only applies inside the house. There is some state law precedent out of Maryland and out of New Jersey to that effect. Now, your listeners should understand that state courts don't have any authority to interpret the federal Constitution, so those state opinions are merely opinions. They have no binding effect on any federal court of appeal. But I think that's going to be the claim by the state of Maryland.
Now, what do you make of that claim? I mean, we talk, in fact, we open this program every night by reading the Second Amendment, which talks about the right to keep and to bear arms.
Right. Obviously, the text itself is fairly explicit, but in addition, there's a very simple logical step, and I discussed this with the Baltimore Sun reporter in my interview with her. The Heller case says quite explicitly that the Second Amendment is based on the right of self-defense, that the right of self-defense is a constitutional right. You may recall, your listeners will recall, that before Heller, there were some opponents of the Second Amendment who said that it was based entirely on the need to create a militia. So the Heller case said, no, that's not the case. I believe Heller was clearly correct, and they said this is based on the right of self-defense, which is a constitutional right that inheres in the people. Now, there are case after case after case, federal and state cases that indicate that the right of self-defense applies inside the house and outside the house. In other words, if I were to attack you inside your house, you could defend yourself against me. Mm-hmm. And if I were to attack you outside your house, you could defend yourself against me. So this is a syllogism. This is a logical series of reflections. On the one hand, the Second Amendment is based on the right of self-defense. On the other hand, self-defense exists inside and outside the house. Ergo, therefore, the right of the Second Amendment applies inside and outside the house. So I think that that's the quite obvious syllogism that the district court impliedly used, and it's my ardent hope, of course, that the Fourth Circuit Court of Appeals will do the same thing.
In the meantime, Professor, what is the law in Maryland now? Is the May issue system, is it gone?
Well, that's a great question. Quite a few people I know have applied for a permit to carry immediately after the Woolard case. Woolard is the name of the case that we're discussing. And several people I know have applied. They've submitted their fee. I should mention that Heller pretty explicitly said that the Constitution does not require the state to allow all citizens to carry, as is, for example, the case in the state of Vermont
right.
and several other states where all citizens who legally own a gun can carry that gun. It is not required that all 50 states adopt Vermont's rule. They can have indeed, I think my best read of Heller, but of course this has to be fleshed out by subsequent case law, my best read of Heller is that, quote, may issue, unquote, is not per se unconstitutional. The problem is that the, quote, good and substantial grounds, that is unconstitutional because that vests entire discretion in the hands of an official like the superintendent of police or his delegate. So, for example, it's the observation of many Marylanders, and I should mention that although I do teach in Arlington, Virginia, as you mentioned, I am a Marylander.
Yeah.
It is the experience of many Marylanders that elected officials all apparently have good and substantial reasons to carry. When they apply for a permit to carry, one seems to observe that those permits are granted, whereas when ordinary citizens apply and say, I was mugged once, or I travel very late at night, or I have some fear, I'm a woman, I'm elderly, et cetera, that's not sufficient. So there is a rule of law problem, as it were. The law is not being applied to officials the same way it's being applied to ordinary citizens. That's gone by the wayside. Pending appeal, that's gone by the wayside as a result of the district court decision. So, in my opinion, the current state of the law is that you have that if you as long as you state that you wish to carry and that you fill out the form, every question on the form, it's a multi-question form, except the question. There is a question, what are your good and substantial reasons? In my opinion, you need not fill out that question. And if all the other questions are filled out, are answered adequately, I believe that they've got no discretion anymore.
All right. Well, listen, Professor, again, I appreciate you coming on the program this evening, sir. A real pleasure talking to you, and I hope we can do it again.
I appreciate it.
Professor Michael Krauss joining us from George Mason University School of Law tonight here on Cam & Company.